gonna run CC 4 years. No probation.
Okay.
Okay, thank you.
All right, the court is calling 2026 CR 002947 State versus Alan J. Hernandez. Could I have parties announced for the record, please?
James Seeloff for the defense.
And are you Mr. Hernandez? Probation, there's no application in this case.
No.
All right. Counsel, have you received all discovery that you review with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury review the evidence in this case and make a decision on whether or not to hold you over for trial?
Yes, ma'am.
And did you understand your attorney has the right to have 2 days pass upon the presentation of the information and 10 days to prepare for trial? Did you understand by entering this plea, you're giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
All right, so the rights I've explained to you, do you understand
Yes,
them?
ma'am.
Are you giving up those rights?
Yes, ma'am. Okay.
Are you intending to give up those rights and enter into whatever plea bargain agreement you've reached?
Yes, ma'am.
All right. Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, are you waiving the reading of the information?
Yes, we are.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with driving while intoxicated, third or more. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I believe he was.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,400 fine. This will run concurrent with 2022 CR 2976. Did you understand that to be the plea?
Yes, ma'am.
Defense,
That's our agreement.
state. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No,
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
guilty.
State any evidence.
Yes, sir. Proceed off receipts, exhibit 1 and all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he's 61 years old and he has a problem, obviously, and together with the motion to revoke, we think this is the only way to go.
All right, the court will sentence you to 4 years in the prison, give you credit for any time served. There's a 2-year driver's license suspension, $1,400 fine, time and money to run concurrent. This will run concurrent with 2022 CR 2976, and the court will recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we're proceeding in 2022 CR 2976. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alan J. Hernandez who was placed on community supervision in 2022 CR 2976 for the offense of driving while intoxicated third or more on June 14, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 21st day of January 2026 in Bear County, Texas. The defendant, Alan J. Hernandez, committed the offense of driving while intoxicated in violation of condition number 1.
How do you plead to that? True or not true?
State no waiver remaining knowledgeable.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, proposed agreement is to grant state's motion and sentence Mr. Hernandez to 4 years in prison.
To run concurrent with the. Okay. Yeah, that's our understanding.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, thank you. State, you may be excused. All right. All right, the court will grant the motion. The court will revoke. The court, as previously stated, is finding violation of condition number 1 true. Court will sentence you to 4 years in the prison. This will run concurrent with 2026 CR 002947, therapeutic community and 2-year license suspension. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
All right, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we got the record. Here's the thing.
Credit for time served? I'm
Yes,
sorry.
he'll receive credit for any time, sir.
I didn't hear it the last time.
Oh, that's okay. Legally, you're entitled to any time that you have served. You understand? All right, we can go off the record. The therapeutic community, I don't have any jurisdiction to have them place you in the program, but on the judgment, it will show that I'm requesting that for you. You really need to do your best to get in that program because you have an alcohol problem, right? And if you don't solve that, what's going to end up happening at some point, you're going to be listed as a habitual. The minimum will be 25 years, or either worst case scenario, you're going to end up driving and killing someone. All right. All right. Good luck to you. When you're released from custody, if you can't find a sober support house to live in, you come back here. I will pick up the phone if I'm still here and find a place for you. Okay. All right. Good luck to you.
I suggest AA.
Mhm.
Good program.
Now that the court proceedings have wrapped up, let's step back and really unpack what just happened in this courtroom, because this case is a powerful example of how the justice system handles repeat dangerous behavior, particularly when it comes to driving while intoxicated. Alan J. Hernandez stood before the court at 61 years old, charged with driving while intoxicated for the 3rd time. And that detail alone is critical. In many jurisdictions, including the one reflected in this transcript, the legal system treats repeat DWI offenses very differently than a first-time mistake. The first or second offense might involve probation, treatment programs, or shorter jail sentences. But by the time someone reaches a 3rd DWI, the law begins to assume something deeper is happening, either a long-term addiction problem, a disregard for prior warnings, or both. That's why this charge carries the weight of a third-degree felony, meaning the possible punishment ranges from 2 to 10 years in prison, along with significant fines. In Hernandez's case, the plea agreement set the punishment at 4 years in prison and a $1,400 fine, plus a 2-year driver's license suspension. Legally speaking, the judge followed the plea agreement exactly, which is why Hernandez also waived his right to appeal. Once a plea deal is accepted and followed by the court, the defendant typically cannot challenge the outcome later. But there's another important layer here that the judge emphasized: rehabilitation. During sentencing, the court recommended that Hernandez participate in what's called a therapeutic community program. These programs are often used in correctional systems to address substance abuse and addiction issues through structured counseling, peer accountability, and long-term behavioral treatment. The judge made it very clear the goal is not just punishment, but preventing the next incident before it becomes a tragedy. And that warning carried real weight. The judge didn't just talk about legal consequences, she talked about the human consequences. If someone continues driving under the influence, there are really only two likely outcomes. Either the legal penalties escalate dramatically, eventually reaching habitual offender status, which can carry sentences of 25 years or more, or something even worse happens, a fatal crash involving innocent people. That's why repeat Dewey cases often create such intense reactions inside and outside the courtroom. On one side, you have the defendant, someone who may be struggling with addiction or poor judgment. On the other side, you have public safety concerns, because impaired driving is one of the leading causes of preventable deaths on the road. Judges are constantly balancing those two realities, holding someone accountable while also giving them the opportunity to change their behavior. In Hernandez's case, the defense attorney even acknowledged the core issue directly when he told the court, "He has a problem, this is the only way to go." That statement says a lot. Sometimes incarceration becomes the only path left, not just as punishment, but as a way to force a pause in a destructive pattern. Now here's something worth asking the audience watching this case. Do you think prison is the best solution for repeat Dewey offenders, or should courts focus more on mandatory treatment and monitoring programs instead? Some people believe stricter prison sentences are necessary to protect the public. Others argue that addiction treatment and supervised recovery programs might prevent repeat offenses more effectively. Either way, the legal message in this case is unmistakable. The system gives warnings, but those warnings eventually run out. For Alan J. Hernandez, those warnings have now turned into a 4-year prison sentence and a felony record that will follow him for the rest of his life. A felony conviction means permanent consequences beyond prison, limitations on firearm ownership, employment barriers, and long-term social and legal impacts. So what's the biggest takeaway from this courtroom moment? It's that the justice system often works in stages. First comes the warning, then the second chance, and eventually, when those chances are exhausted, the consequences become unavoidable. And this case sits right at that turning point. If you found this courtroom breakdown insightful, make sure to hit that like button, share your thoughts in the comments about whether this sentence was fair, and don't forget to subscribe for more real courtroom drama and legal analysis.